Okay, I regret to see the nation mourn over the week. Okay, pleased to see you again. The topic in this context is actually highly structural, and the kind of structural alterations would not be desired at first instance, since they are highly traditional and actually embedded to pertain to our basic concept. For example, we often endorse the nobody be beyond the law. That is the statement exactly from the Paula Jones in the case. How do you consider the pro-presidentialism? Actually, we have a good excuse. For example, congressional oversight and the monitoring law of a civic pressure group, and the presidential desire to be re-elected, a scrutiny by the press, often could function formally and informally to check the president. So, how do you perceive extended law of judicial branch? Could it be seen to transgress the original commitment of separation of powers principle? So it depends, perhaps, on new framework, for example, new perspective, or public policy to adapt with the changing circumstances. Others may have rewrite the Constitution provision and in contemporary terms and understanding. For example, consider the 14th Amendment of the United States Constitution. So, the amendment should be prepared for slavery system and the tragic event of a civil war, kind of a national crisis. So it may be reduced in terms of could be expanded to evangelize or universalize the sovereign goal of human rights, for example. So actually interesting, and we will further take an overview about the point of contention raised by advocate of pro-presidentialist. What is that? And the evidentiary privilege could be applied in analogy to this kind of situation. So how do we find it to be constrained for such important and best office in constitutional structure? Under the well-established crime-fraud exception, however, attorney cannot invoke lawyer-client privilege when independent evidence confirms that they are trying to shield from view ongoing criminal misconduct and obstruction of justice. Likewise, the presumptive privilege shielding conversation among jurors is when there is independent evidence that the juror has been bribed and is using the jury room itself to obstruct justice. How about this case involving President Nixon? Did the court possess sufficient evidence to subpoena the conversation? Actually, the evidence now now the court and United States pursue to collect would not mere evidence of conspiracy. They are conspiracy itself. So it is distinguishable from other normal context of evidentiary rule. It's actually a physical product to be targeted, to be triggered. The professor also perceived the head trigger of a judiciary would be highly driven to imperialize the judiciary. However, how do you connote the concept rule of law? And could you properly consider the judiciary sanctuary of that responsibility? These usual circumstances, executive privilege is. Berger instead wrote a sweeping opinion that had the virtue of not attacking Richard Nixon personally and the vice of making no sense when amnesty applied to honest presidents. So we have a scope of a high needs, actually necessities, as frank. The president are responsible to many important decision making, foreign policy. What he is actually a commander-in-chief, as mandated by the Constitution. His status is distinctive, and office is unique. The justices doubtless fear that Nixon might defy their orders. This explains why all 8 participating justices signed onto a single statement, however ill-reasoned. So it is a rather quick judicial fix to constrain many other possibilities, perhaps progressed by Constitution. What is Governmental Ethics Act? Later on Clinton administration was started report, and his responsibility emanates from that statute. With the court using several procedural tricks to intervene with lightning speed, was to short-circuit an impressive effort by Congress to take seriously its own role under the Constitution. With the result, the later Congresses will lack a modern model of how to do presidential impeachment right. The framers, knowing the president might occasionally be wicked, make Congress the main watchdog by oversight and impeachment. Unlike a known prosecutor or plaintiff trying to take down a president with the aid of judges, Congress would be democratically accountable. So, the political branches could be consonant to address the popular will. The context could be crippled within this institution. His viewpoint would support that the structural lesson taught by Nixon was different. Trust the court, distrust the president, and ignore the Congress. The Independent Counsel statute passed in Nixon's shadow reflected and magnified its pathologies. So, in Watergate, Nixon's White House itself had picked Cox and Jaworski and retained formal power to remove these inferior executive officers at will. Politics, not law, framed whether an outside prosecutor would be named, who he would be, how he would operate, when he would be removed. So this weaknesses may not prevail in Whitewater case. You see in the effort of Starr, Independent Counsel Starr, would be purchased, and we could see it in public acclaims generally, how they perceive. Actually, what is the incident? It is private. Eventually, the Senate did not approve the impeachment. What arguments could be raised in terms of dualism between official and official misconduct? The sexual relations with Monica Lewinsky would be consensual. It might be seen as private, purely the privacy right was shielded from view. However, what's the place to be perpetrated? It is within the White House. Could it have any implication between official and unofficial misconduct? The system worked beautifully in a way that made the framers proud. Though picked by Nixon's own administration, Cox and Jaworski were lawyers of a great credibility. Actually, this system was imported by Korean authority, and we now have that content in the same. And the independent counsel work part-time. You see, never dissimilar between two nations. Independent counsel Starr also perform his duty part-time while working in his law firm. Often it would not be easy to elect lawyers of great compromise, great promise or credibility. It may be the selection may be critiqued as impartial, what is. Rushing to claim credit for reform, post-Watergate lawmakers scurried to fix the founders' unbroken system and created a constitutional Frankenstein. Under the independent counsel statute, judges would pick special prosecutors and nominally supervise the operations. Even if we are successful to elect fair and competent lawyers, we may confront other challenges. Actually, the kind of dual secrecy may remain very powerfully with judges and independent counsels. Their role, attitudes, and style of official duty actually could be shared in same at least in high similarities. Sure, judges should not be in the business of monitoring the prosecutor's ongoing investigation. But the statute naturally follow from Nixon, turning its weird regulation as law gambit into literal law, limiting presidential removal in violation of law bias, and injecting judges into fundamentally intra-executive decisions about whom and how to prosecute. Judges may be tempted to pick a fellow judge with no prosecutorial experience. And the judge-prosecutor will predictably make rookie mistakes. Their fellows and peers they would be less skillful to respond with a public they may be surely technical to persuade the whole of national compassion. It then becomes impossible to say they are inferior to someone if judges may renege on his statutory responsibility. They actually put into a situation considering all sorts of secret material in closed chambers in violation of a deep judicial norms. So that's the point. The professor perceived as actually vile and fraud in essentially in this system. And we have abstention doctrines. It requires judicial restraint. However, this commandment would be perverted in this case. And often federal judges will never involve themselves in procedural issues arising in an ongoing state prosecution. There would never be such an attitude in the case of independent counsel. So oftentimes the court breathlessly rushes into the middle of a presidential impeachment to save the country. When the independent counsel statute first came before the court in the 1988 Morrison versus Wilson case, 7 justices voted to uphold it. Morrison winked at the word inferior, cited the fact that Article 2 vests all executive power in the president, and disregarded the objection the judges were performing plainly executive tasks. So it could be grounded constitutionally for the viewpoint of objection. The judges were performing plainly executive tasks. So the constitutional structure is kind of wonderful which should not be transgressed. Actually, we may complement the ambiguities, however, could not contradict this basic framework or intent. So that is the constraint if we discard the option of amendment, what is. And it is also skeptical if we alter any articles through amendment. The second amendment about right to bear arms is notorious. Actually, many elaborations in terms of public policy were pursued. There could still be in stalemate without any complete resolution. A satisfactory result would turn unlikely. Perhaps the presidential imperialism was a red herring, a product of westward thinking. The word imperial conjures up images of kings ruling by divine right. Presidents are elected by the people. When they are unable to do the people's business because of unilateral decisions of unelected folk, which way does imperialism cut? Kings rule for life. Presidents are limited to 2 terms. And so even if lawsuits are generally barred against sitting presidents, plaintiffs will typically have their day in court afterwards at a time when the business will not thereby be prejudiced. So Lawrence Walsh, Ken Starr, Susan Weber Wright, the judges, a independent counsel. So we have another example about Paula Jones case later, shortly. How Jefferson and Burr had remained free to disregard Marshall's subpoena simply by dropping the case. So the professor now consider time has come to undo the judicial flaws charted of history. So now the time to promote the presidential status, in restoration and in accordance with the adequate terms and structure of Constitution. Stevens in John's opinion leaned heavily on Burr, but never paused to consider how Jefferson and Burr have remained free to disregard Marshall's subpoena simply by dropping the case, as I've reiterated. How do you perceive if Nixon could in 2 steps fire Jaworski and keep the tapes? And the professor also critiqued that Jones reflected a remarkably self-satisfied view of a federal judges. So, on the proper view of a Fourth Amendment privacy and federal rules of civil procedure, Monica Lewinsky should never have been asked about her purely consensual sexual ability. Nor should Clinton have been forced to answer, given that his answer could implicate serious privacy interests of non-party of this civil suit in the absence of a compelling need. Judge Wright is not alone. Most federal judges have internalized the master narrative, and its Nixon was a heroic decision where heroic judges upheld the rule of law and saved the country. Judges are presumptively good, and presidents and presidential privileges are presumptively bad. This is the theme of a trio of Clinton-era privilege cases decided by circuit courts involving Secret Service privilege and government attorney privilege. So let's turn to see the attorney-client privilege in this context. So could not be applied if they speak to government attorneys. So now the White House personnel and the president may not invoke the attorney-client privilege. Is it fair? And does it satisfy your sensibility of balance about competing interests? The attorneys represent the government, and somehow inferior star embodies the government, thereby displacing a duly elected president. In their own branch, judges think otherwise. Law clerks are paid by the government. But many judges have told their clerks they owe an absolute duty of confidentiality to the judge under attorney-client privilege. So let's get a boomerang about this logic and narrative involving the judicial office. So the justice will not take kindly to any effort by the president to force their law clerk to answer questions under oath about the justices' personal lives. More generally, if the chief executive thinks that the Secret Service should remain secret and an inferior officer disagrees, why do judges heed the inferior rather than the chief? So it should never go so far to create the pitfall or to vitiate the congressional spirit. However, actually, now honest president would face unextended difficulties in carrying their official duty. He should have been treated as if he instructs his aides to cooperate fully with his White House counsel. As if he could assure them that what they say will be privileged so that they will tell the truth, and he can fix the problem, and if necessary, remove the bad apples from his administration. But the circuit court opinions prevent the president from making his assurance state. And the result is that judges are impermissibly interfering with an honest president's ability to run his own separate branch of government. This is the wages of Nixon. So, according to his viewpoint, modern presidential law is misshapen. The remaining task would how to undo is fallacy. And he is enthusiastic to alter all unnecessary and improper premises or court holdings in due regard of a presidency. Pro-presidentialism is his main theme in this symposium. All three branches of government are to blame. Blame Congress for abdicating its proper oversight responsibilities and for crafting such an abominable independent counsel statute. Blame presidents for having been at times crooked and for opting to litigate key issues of presidential privilege on smelly facts. Blame judges for smelling the facts while missing the big picture, and also for their institutional hubris. So, how would you consider the worst, the bad court commitment could create a pro-presidential backlash of sympathy. Now, the post-Watergate presidents of both parties have been badly blooded. Pro-presidential reform, need not be seen as triumph of one party over the other. And also, one interesting article about Paula Jones' case would come from Susan Pitti, junior staff member, Journal of Contemporary Law. So her dealings would not be extensive and very neat to address the case pattern and the holdings by the Eighth Circuit and the United States Supreme Court. And she investigated background shortly involving the attributes of cases of history and provided analysis in 7 pages. In Clinton Jones, the article was featured in Journal of Contemporary Law, published in 1998. In Clinton Jones, the United States Supreme Court was presented with the opportunity to expand the doctrine of a presidential immunity set forth in Nixon Fitzgerald. So he addressed a comparative analysis with Nixon Fitzgerald. What is the consequence identified in district court? What are the claims in district court? For Jones, alleged Clinton deprived her of rights protected by the Constitution in violation of 42 U.S.C. 1983. Second, John charged that Clinton and Ferguson conspired to violate her federal rights, also actionable under federal law. So civil action in Joinder with a other name Ferguson. He is a state police officer who conspired to give a sexual service for then Governor Clinton. Jones asserted a state claim for intentional infliction of emotional distress Finally, Jones asserted the claim for defamation of character. Clinton responded to the complaint by filing a motion to dismiss on grounds of a presidential immunity and requested the court to defer all other pleadings and motions until after the immunity issue was resolved. So the holding in the district court would be the motion to dismiss must be denied, predicated on immunity grounds, and discovery could proceed, but ordered that the case would not go to trial until the end of Clinton's presidency. In so holding, the district judge was not convinced that a president has absolute immunity from civil causes of action arising prior to assuming the office. So one point to be made distinguishable would be the time of a misconduct. Did it occur prior to assuming the office or in the period of tenure? However, the district judge was persuaded by some of other reasoning in the Fitzgerald decision that deferring the trial, if one were required, would be appropriate. In this case, a divided panel of Court of Appeals affirmed the denial of the motion to dismiss, but reversed the order granting temporary immunity until the president leaves office. Judge Baumann, writing for the majority, pointed out that the president, like all other government officials, is subject to the same laws that apply to all other members of our society. The majority also rejected Clinton's separation of powers argument, suggesting that judicial case management, sensitive to the burdens of the presidency and the demands of president's schedule, would avoid the perceived danger. Clinton filed a petition for certiorari and raised 2 points submitted to the court review: whether the litigation of private civil damages action against an incumbent president must in all but the most exceptional cases be deferred until the president leaves office, and whether a district court, as a proper exercise of judicial discretion, may stay such litigation until the president leaves the office. The court granted the petition for certiorari, recognizing the importance of defining the scope of presidential immunity as applied to the president's unofficial acts. The majority of the court's opinion was penned addressing Clinton's contention the civil suits against an incumbent president arising out of events that occurred before he took office must, in all but the most exceptional cases, be deferred until the president leaves office. So historical evidence was presented to support this argument, and so many efforts. Justice Stevens, writing for a unanimous court, first looked to precedent to refute the president's argument that the immunity doctrine should be expanded to encompass the president's unofficial acts. The court reiterated the underlying rationale for affording certain public servants immunity from suits for money damages arising out of their official acts is inapplicable to unofficial conduct. Clinton's second argument, rooted in historical evidence, also failed to persuade the justices that he should be granted temporary immunity. Finally, the court recognized Clinton's strongest argument in support of his claim was based on both the text and structure of the Constitution. Clinton's arguments were premised on the nature of the presidential office created by Article 2 of the Constitution and on the potential to upset the delicate balance between separation of powers. The justice accepted Clinton's argument that he occupies a unique office with powers and responsibilities so vast and important that the public interest demands that he devote his undivided time and attention to his public duties. However, the court held that allowing this action to proceed did not violate separation of powers principle. In further support of his position, the court found that although a federal court's exercise of its traditional Article 3 jurisdiction to decide cases and controversies may significantly burden the time and attention of the President, this does not violate the Constitution. Two propositions support this conclusion. First, when the President takes official action, the court has the authority to determine whether he has acted within the law. Second, it is settled that the President is amenable to judicial process in appropriate circumstances. The court finds that it logically follows from these two propositions the federal courts have power to determine the legality of President's unofficial act. So, the author's viewpoint, and also according to the court, remedies such as impeachment, formal and informal checks, as I've commented earlier, was scrutiny by the press, vigilant congressional oversight, and President's desire to be reelected would sufficiently prevent misconduct. And he also explored the case Nixon versus Fitzgerald. In the case, the court held the President has absolute immunity from damages liability predicated on his official acts. The Supreme Court, in a sharply divided opinion, held that Nixon was entitled to absolute immunity from damages liability based on his official acts. In his plurality opinion, Justice Powell noted that the Constitution, federal statute, and history had guided their previous decisions concerning immunity of government officials from civil suits. The court further stated that these decisions had also weighed concerns of public policy, especially as illuminated by our history and the structure of government. Justice Powell specifically recognized that presidential immunity is rooted in the separation of powers under the Constitution. So in this class, we investigated a deeper a feature of a separation of powers principle, which has played out to meddle on important area, but not straightforward, involving three branches of government. We also noted that the public policy is very controlling and influential, how to shape a adequate extent and limits exception. So the focus was exerted on a presidential immunity. However, actually, the delicacies would involve extensive scope of constitutional issues. For example, war-making authority between Congress and President, how to intervene by the judiciary to resolve that controversy in any desired policy terms or laws. And also some key area of national security and foreign policies also would be under review, involving many of national institutions, law and rule-making power, and also constitutional intent of framework, a structure, authority, and formal aspect of a agreement and disagreement also be centralized into any merit you consider thus far. My intention is to survey some of elements in dealing with administrative hearing. What is controlling law? And we also consider a threshold question: what triggers formal adjudication under the APA? And the components of a hearing and determination of the record and statement of reasons, and also another view of informality and formality of decision making would be surveyed. Along with the topic, we will take time to consider some of relevant cases to facilitate our understanding. And also, what is that? We have three frames notorious of progress of this class. The higher authority from a constitutional due process. And also, specific statute could create and authorize the agencies to act on administrative hearing. The agencies would act in the basics freely on the statute and rules created and implemented by themselves. In some cases, we would compel it could continue progressed be progressed on administrative hearing. When is it imperative to hold administrative hearing? When it is desirable. There is no absolute rule to bifurcate this issue into any meaningful terms. So it actually depends on the statute in the second instance, except the Constitution. And we also, general context of a commandment could come into play, administrative procedure. The act is general to refer to in the case where we have no specific authority of statute. The act provides kind of a legal frame, the notorious words, what, on the record. On the record. The administrative agencies need to progress the action or any ways of a formal carriage of their duty, determination, what a rule making to be based on administrative hearing in the case that falls within the requirement on the record. So the scope of elements, requirements could be provided to compel the agencies to act on the administrative hearing. However, the call would not be dispositive, depending on what entirely relying on that requirement. On the record might be a first point of reference. However, even if the administrative action should be processed involving that requirement on the record, the administrative agency may, on his own definition, and of course in the maximum extent of a administrative finding, could waive the administrative hearing. So it is actually not a imperative. So could be resolved on a case-by-case basis, depending on the situation. So that would be surveyed briefly, and the components of hearing would be explored, which derives from the Goldberg ruling. So it is a landmark case to expound the concept of due process, and the court had developed four important themes as components of hearing: timely and adequate notice, disclosure of opposing evidence, and right to confront adverse witnesses, oral presentation of arguments and evidence, and the right to retain an attorney. So it is highly desired not to derail these important components to they satisfy with the due process ideas. And the administration would have to determine on the record. They should be an impartial decision maker, and statement of reasons have to be procured to ensure the process in a due context of Constitution and other civil requirement. And also that is the first point we have to report faithfully as a civil servant. So it would not be entirely formal as seen as, so the informality and discretionary context of response could let in extended a space and leniency. To support this point of consideration, I like to illustrate EEOC, we have experienced some of high spirit to cope with a sexual harassment in the workplace. And during the Carter administration, the federal response was created and implemented. For example, what is that? EEOC guidelines on discrimination because of sex. It was begin with implementation since 1980 in the last months of Carter administration. The Equal Employment Opportunity Commission published its first guidelines on sexual harassment. So we need to know that it took well into the 1980s before even progressive institutions like the University of Massachusetts adopted kind of a policy we will explore briefly in the subsequent class. So you can see what the university version about a sexual harassment policy in October 2004. It describes to begin with a basic policy. What is the actual extent of a policy response and what is the goal and spirit? However, do you see if this university procedure satisfies the EEC's guidelines? If so, why? If not, why not? There's a problem we need to consider next class. What impact does the informal process have on the formal procedure? The University of Massachusetts policy states that there are two modes of resolution for formal complaints: mediation and a hearing. How is a mediation different from a hearing in this context? And finally, think about what impact mediation, an informal process, has on the formal hearing process. So this case illustrates an exciting niche when we consider the administrative hearing. So we also ascertained it is actually vague between informality and formality. So it falls within the discretion of administrative agencies, provided if it entirely fails the whole scheme of a administrative hearing. So it can be altered by a judicial intervention. Otherwise, we will see a dual. The aspect is highly amenable to the situation. And the polished discretion of administrative agencies. So in the University of Massachusetts policy, you also know a scope of a system which depicts procedures, for example, purpose and scope, and confidentiality. It is a governing idea, spirit to treat the issue of sexual harassment in any desired way. All parties involved in any aspect of this process will act at all times to preserve the confidentiality of these proceedings. information will be shared with those individuals who have a legitimate and operational need to be informed, and to the extent that it is necessary to maintain the effectiveness of this process. Individuals found to have violated confidentiality of this process may be subject to disciplinary proceedings consistent with the provisions of the collective bargaining agreement or the applicable administrative rules and regulations. And deadlines, requirements for participation and withdrawals, retaliation, and penalties, and filing sexual harassment complaints, initiating a complaint, informal resolution, self-help. So Joseon University is a private one, so we could not impose any public concept over the midst of hearing. However, University of Massachusetts is the entity of actually a state agency, informality. So could apply a stringent term of a public mandate kind. Informal resolution, self-help, and mediation, a formal resolution. And also we have we may be given some lesson between mediation, informality, and a formal resolution, filing a formal grievance. And also organic provision could be found, for example, the sexual harassment board and the hearing panel and formal grievance procedure. And of course, we may be exposed to the kind of a routine argument, the right to retain an attorney, and the concept and holdings will largely be shared. For example, how we compensate the attorney fee for the winning party, who will bear the cost which arises from retaining an attorney. Actually, the reason to impose a determination on the record and statement of reasons would underlie the policy goals that the administration should act as an impartial decision maker, and also could civilize the ways of action others to share for the constitutional ideals and other. And we have not exhausted all the topics to be deferred to the next class. And we also consider additional cases, as I've commented, along with the basics of this discussion in topics. Okay, thank you for your attention. I'll see you in the next class.